Listen, what we want to talk about, and I've got to tell you, Andrea and I are also involved in a state bar committee that's I think the clumsy, it's the state bar committee with the worst name. It's called the State Bar Standing Committee for Legal Services to the Poor in Criminal Matters, and I think we need to change that so we can have a cool acronym like she had earlier, like COAST. Because our acronym actually comes out to SBLXNM. So we're working on that. But in the meantime, we're working on some other things, and one of them is the development of what are called the performance guidelines for non-capital criminal defense representation. But what I want to do is Andrea's going to talk about those guidelines. Chief Justice Quinn is going to talk about problems, not just with the guidelines, but with representation generally. But just to focus this discussion, I have to tell you, there are some basic truths that rarely get brought into the discussion about improving indigent defense in this state. I think basic truth number one is that most of the lawyers doing indigent criminal defense work really don't care about whether they do a good job or not. I'm sorry, that's very heretical. I know people aren't supposed to say that, but I want you all to think about this for a minute. Even if they want to care, how do you do that? Did you see the numbers from Dr. Fabello earlier? $310 a case is the average amount of money that is being paid to these folks in the state. $310. Now, I don't know many lawyers that can afford to care very much for $310. And the truth is, and I got to tell you, Buck was fantastic. Buck Files is not only the kind of lawyer that we ought to try to be, and that those of us that have come up in this profession did, because that's all I really ever wanted to be, was a criminal defense lawyer like him. He was the example, along with many others, and some of the early founders of the Texas Criminal Defense Lawyers Association, and whose contributions are still part of the memory of that group, who set the tone for lawyers like me. These are the people that you looked up to. But they are very different and a very far cry from the bulk of lawyers currently doing indigent defense work in Texas right now. As part of this badly named committee, I've gotten to travel all over the state, and I've gotten to see a lot of people who are doing this kind of work. And I have to tell you, they're very different generationally from the older ones like myself, who believed in the beginning that, if you did court appointments, it was something you did as kind of a way station until you got real cases where people paid you real money. Now, however, we've got a different kind of subculture. We have lawyers, a lot of them, whose whole idea of practicing law is turning in vouchers on time for that precious $300 a whack, and not much more. They're not going to file motions to get an expert, because they're not going to be appointed to a case again if they do that. They cost too much money. How many of you all in here are county administrators? Quite a few. Look, I understand your perspective, I think. You are worried about efficiency and streamlining, all that technocratic stuff we talk about moving people through the system efficiently. Judges get worried about that. Administrators and county officials get worried about that. As Buck pointed out, a criminal defense lawyer's job is not to worry about those things and to only worry about one case at a time. And the minute a criminal defense lawyer starts thinking, my job is to help the system move smoothly, he's no longer doing his job. Our job is to help the system not move smoothly. Period. Because a smooth-moving system is a system that moves smoothly over whatever individual is getting accused and is caught up in that system. And that's okay. That's the way our system is supposed to work, but I fear no longer works that way. Now, I want to throw this out to you all, just so we can, and we're going to have a discussion about what we're trying to do with the state bar and with the guidelines. It's very tempting to look at our current situation and say, look at all the money we can save, or ensure, okay, we're not going to get great representation, but come on, they're guilty, and we need to keep moving these people through the system and being efficient about it. And we think that's a cost saving. But if you also think about it, the truest function of criminal defense lawyers is to operate as a check and a balance on prosecutors. When you don't have that, when you don't have lawyers that are operating adversarially, which in many counties we do not anymore, When you don't have that, you have prosecutors that are doing what they want to do without very much fear of being stopped. That means prosecute more people, grow their budgets, put more people in jail, and that's going to cost everyone. So there are hidden costs to what may look to be making things more efficient and cheap in the here and now that I think you need to think about. The truth is, the adversarial concept that we have based this system on has begun to, I think within the last 10 years, completely give way to a system that's trying to handle too many people with too little money. Now, I'm very pleased, Tony Fabello mentioned earlier that I've been formally given the baton from him of gloomiest guy in the indigent defense movement and community. And I actually thought I already had that title beforehand, but he gave it to me. And I am gloomy about the future because I don't see a time where we're going to be expansive with money. I see a time where we're going to have less money to work with, more cases to process, and fewer lawyers who try to be buck files or try to be a good lawyer and do their job. I was talking to Jack Stoffregan, who's out here and has done great work running the capital murder public defender office. And he said, we got a great result up in Randall County the other day, which for those of you that are from my part of the world know there's a reason we refer to it as the People's Republic of Randall County. They're a little tough to deal with. I think they accounted for like more capital murder prosecutions than Harris County last year. I'm not sure. That's a joke, a little joke. But a lot. And Jack told me that they had gotten a case reduced to life imprisonment and talked the state out of prosecuting as a death penalty case. Great result. That's what lawyers are supposed to do. It only took 4,983 staff hours to get that result done. Because the truth is, if you put 4,000 hours into a case in the way that you should and you're a criminal defense lawyer, you will get the job done. Now, how do you do that when you're going to be paid $300? You don't. But I will tell you, do we see lawyers challenging those kind of low fees that they're paid? No. Very, very few of those challenges are being made to the administrative law judge in their district. Why? It's because they want to keep getting that $300. They're depending on that $300. What we're trying to do is take small baby steps, this time through the state bar, to give lawyers an opportunity to do better by showing them how to do better. And it's my hope that with these guidelines that we've enacted, we're going to finally start at least getting a baseline of performance that any lawyer ought to be able to be measured by. Anyway, with that said, I'm going to turn it over to Andrea. Thank you.
Hi. My role today is to talk a little bit about what the guidelines are and how the State Bar Committee developed them and how we think you may see them used in your communities by defense attorneys and how they can also be incorporated into your Fair Defense Act procedures and also can be used from the sort of county administrator side to take a look at how indigent defense services are being provided in your community. The guidelines are a guided roadmap of potential courses of action and best practices for every stage of a state criminal proceeding from arrest through direct appeal. So there are a few things in there that are presented in a mandatory way. You must meet with your client promptly. You must consider various avenues of investigation. You must consider different types of consequences and how that could affect, plea negotiations and what you tell your client about a possible disposition. But most of the guidelines are really just a list of options that defense lawyers should think about as they approach a case. The bar couldn't appropriately tell people, oh, you must file a motion to suppress in every case. A motion to suppress is not, warranted in every case, but it's a list of things the defense lawyer should be thinking about in every case so that they don't miss those things, so that they don't miss the case where a motion to suppress is appropriate. So most of the guidelines, which are about 23 pages, are really just a list of things that defense lawyers should consider, a list of types of investigation that they should consider whether that type of investigation may yield evidence that benefits their client in that case. And that's how we hope defense lawyers approach them. We had a sort of long, animated discussion with the organized defense bar when we were working on the guidelines, and I think, one of the main concerns that people had is that we were going to tell them how to do their business, and how could we do that if we had no idea what their case was. And I think that as we had that discussion, that people became more comfortable with the fact that, in general, that's not what the guidelines do. They are really meant to help lawyers think through how they approach a case. And this is in a state where lots of defense lawyers are self-trained. We don't have a lot of public defender offices where people can go out of school and kind of have a supervisor who helps them learn how to be a criminal defense lawyer. They're teaching themselves, they're hanging out a shingle. And so a tool like this can be especially valuable in a state where a lot of the lawyers are teaching themselves how to practice. The guidelines can also be that mirror that Amy Bach mentioned this morning, that even lawyers who've been practicing for a long time can kind of hold the guidelines up to their practice and the way they've been practicing law and re-examine what they were doing or how they handle their cases routinely. When we were working on the guidelines and having a discussion with TCDLA, there was a really long email string, and you would see emails appear on there. Well, these guidelines say that we should file bond reduction motions when our clients are in jail and can't afford their bond. And we never do that in our county. We don't get paid for it. The judges don't want to see that. So, we don't think that should be in the guidelines. Or the guidelines, where you have a problem with the guidelines because they say we should go meet with our clients promptly. Well, the DA hasn't even looked at the file. There's nothing we can do in a case. We don't go meet with our clients here because it's just a waste of time. There's nothing we can do early in a case, so why should we go meet with our client? Those questions, they really were holding up a mirror to practices that people were taking for granted. They had quit filing requests for investigators in misdemeanor cases because we don't do that in our county. The judge wasn't even having to turn them down anymore because people just quit asking. And so this is what we hope that a function we hope the guidelines can serve, even with more experienced defense lawyers. And one of the things that I thought was really good about this discussion, even though it got kind of heated at times, was that you could see some of these emails just drop into we weren't the people responding negatively to them. The defender community that was part of this very public conversation, nobody was going to help these guys who were like, no, I really just never file a bond reduction motion. That would just sort of drop like a lead balloon in the conversation. And, those lawyers would, I think that's a signal to those lawyers that, they weren't getting a lot of Me Too emails, right on. It's like, oh, wait, I really am out here, in this little echo chamber of, my local jurisdiction may be too long and need to take a second look at how we're doing things here. So that's what we hope the guidelines will do. They are, primarily is the bar, and we hope that this will contribute to the self-regulation of the profession, and they're primarily a tool that we think will be used by defense lawyers. And so, I think it's not obvious to a lot of people who work on sort of the county administration or judicial administration side, how does this directly affect them? I think that you will see the guidelines in two ways. First of all, we hope that this is going to change how defense lawyers conduct business in your jurisdiction. And, that because everybody, that is going to push the other actors in the system to do things differently. So if you are in one of the jurisdictions where you have not seen a request for investigative expenses in misdemeanor cases in the last 30 years, you may start to see some of those, and your system is going to have to adjust to that, and your budgeting may have to adjust to that, and you hopefully will start seeing more of that inappropriate cases from lawyers practicing in your jurisdiction. I think the guidelines also put a lot of emphasis on collateral consequences and the duty that lawyers have to be knowledgeable of the collateral consequences that their clients will face if they're convicted, and to provide advice about those collateral or information about those collateral consequences in plea negotiations. That part of the guidelines is going to require counties and judges to kind of rethink, what resources are available to their lawyers for their lawyers to perform those functions, whether that's training, whether that's some sort of expert assistance that lawyers may be seeking in your courts. And so as lawyers incorporate that aspect of the performance guidelines into their practice, you're, I think, going to see consequences of that in what they come and ask the court for, or what they need, or what the court may want to require in terms of training and expertise in areas that haven't really in the past necessarily been considered core defense lawyer functions. Now it's very clear that that is part of the job. And I think the other way that you're very likely to see sort of direct effect is in the handoff between trial counsel and appellate counsel. The guidelines have, one of the part of the guidelines that is mandatory is requiring appointed trial lawyers or retained trial lawyers also to hand off their cases in certain ways, to formally withdraw, to help their clients request appellate counsel and get that out there, to file the notice of appeal before they just walk away from the case after a plea. That is you're going to see that in your court as well. Like if some of your appointed lawyers are just kind of turning in their voucher but not filing motions to withdraw, hopefully you're going to see a lot more motions to withdraw and handling that formally, and have to adjust your practices to that as well. There's also recent state legislation on that issue, so that is going to be required by that legislation in addition to the guidelines. So those are some of the ways that I think you'll see defense lawyers come to you asking for things they may not have asked for in the past. And we certainly hope that the guidelines will encourage counties as well to reconsider, to think about how to inform how counties respond to those requests. So, if you have people coming to you and saying, we need investigative services, the guidelines talk about when that may be appropriate, and it may be in situations that you aren't doing a lot of seeing a lot of investigative services in now. So we hope the counties will look to the guidelines when they are evaluating what defense attorneys need to do their job properly. The guidelines can also be incorporated into your Fair Defense Act plans, and the non-capital guidelines follow capital guidelines that the committee adopted in 2006. And those guidelines have been incorporated into some of the regional plans, so there is a model about how you may take these guidelines and use them in your Fair Defense Act plan. It can be as simple as requiring lawyers who want to be on the list to read and be familiar with the guidelines or to go to training in them. There's going to be a 1-hour video up on the State Bar website about the guidelines. It could be requiring training in the guidelines in order to get on your list. That's a very easy way to incorporate the guidelines into your practice so that you know that all the lawyers who accept appointments in your county will have some familiarity with the guidelines and what they require. I think the guidelines may also require counties to think about caseloads and compensation in a way that is different than what they have done in the past. My experience is that a lot of counties that use appointed counsel system don't track attorney caseloads and don't think that much about how many cases lawyers are taking in their counties. And we've seen appointed lawyers have caseloads that are extremely high and where, frankly, it'd be impossible to do even the minimum of what an attorney is required to do under the guidelines if they have 800 cases a year. So I know the task force is looking at providing support to counties that do want to track caseload for appointed lawyers, and hopefully the guidelines will just be one more thing that encourage you to use that resource when it's available and think about what a lawyer really needs to do. It's not the 5 minutes you see the lawyer in a plea hearing. The lawyer's supposed to be doing lots of things before that happens, and you're not just compensating them for that hour in court. They're supposed to meet with their client. They're supposed to do whatever investigation is required in that case, even if it's just reviewing a police file in certain cases. Do that. It's not just showing up in court, meeting the client for 5 minutes, and pleading guilty. So, the caseloads and the compensation paid to lawyers need to reflect what is the minimum amount of work that they should be doing in a case. And it's a lot, often we hear, I know it's easy just to focus on what you see, but there should be a lot more going on than what you see during, a plea proceeding that happens really quickly. So that is sort of a summary of the guidelines. I'm going to turn it over to Justice Quinn now, and then we all may come back together to answer questions or have a discussion at the end.
What they said. Listening to Andrea talk about the guidelines, I thought they would be pertinent not just for determining how well appointed attorneys perform, but I think they would be very useful in handing to law students and saying, if you're going to practice criminal law, this is a good start. So I don't know if you've thought about that, but if there's anybody from law schools listening, I would recommend you look at those. As Andrea was saying, too, one of the provisions in there talks about the handoff, so to speak. I'm an appellate judge. I guess messing with Jim in the municipal court qualified me to go to appellate court somehow, but I'm there anyway. And being an appellate judge, I have a particular interest in our performance and the representation there. I was looking at these guidelines, and I noticed that there are some additions that can be made to them. I think they're a very good product, but there's some additions that can be made to them to focus on the appeal. And before I go into those, I want to ask some questions first. How many of you attorneys are in here? Okay. Majority of you are attorneys. How many of you do appellate work? A lot less. Okay. How many of you seen LA Law? How many of you seen Boston Legal? Where do they usually try? Where do they usually appear? What kind of court? A trial court. A court that reverses things? I think I've only seen them once where they have an appellate court. There's not any shows about appellate courts. They're all about trial courts. You want to get attention. You want to get noticed. You want to have good experiences, have great war stories about how you handled a witness or how you dealt with the attorney on their side in front of the jury, and dropping your keys at a tense moment or something like that to cause distraction. You do that in trial court. You're never going to see anything about appellate court because it's boring. It's boring. But if you want to make an effect, let me ask you this. What's in common with these cases? Powell versus Alabama, Gideon versus Wainwright. And these are cases I've heard this morning mentioned here. Akey versus Oklahoma. Brady. Well, these are, I added. Batson. What was that case that you just worked on? Rothgary versus Gillespie County. What's in common with those? Are you going to see, well, Gideon, you can see a movie about that. But you going to see any of those other cases on TV? No. But every one of those decisions weren't written by a trial judge. They were written by an appellate judge. And they were written with the influence of an appellate attorney. An appellate attorney in Gideon who thought outside the box. Yes, he had a lot of help from his client because his client's the one that first written longhand, sent it to the Supreme Court and said, I think I'm entitled to an attorney. The Supreme Court looks at it and appoints him an attorney. And then that Gideon comes out of it. It's appeals. We may not have a lot of glamour, but you have a lot of effect. Next question. When does an appeal start? One of my staff attorneys back there hiding, Minnie McLaughlin, she's taking notes because we're going to try to do some type of program to get more attorneys. But when does so I just wanted to recognize her. I've got another staff attorney listening in, Elise Blunt. Hi, Elise. But anyway, had the question, when does an appeal start? And the gentleman raised his hand. Sir, in the red shirt, yeah. You raised your hand when I said, when does the appeal start?
I say at the arrest.
Trial attorney gets appointed. Arrest. When I was teaching law school, I'd always ask them, the class, there's an appellate ad class. When's an appeal start? Oh, when the judgment happens. Okay. The guidelines talk about handing off to the appellate attorney at the end of the trial. Talk with them. The appellate attorney talking with the trial attorney to see what issues need to be incorporated in a motion for new trial. If that's when an appeal starts, it's too late. Point of arrest, point of indictment. When your counsel's appointed, indictment. Can you bring up every issue on indictment now, a defective indictment on appeal? For the first time on appeal? No. Evidentiary matters. Can you bring them up first time on appeal? No. All these things have to be raised now in trial because of a rule that we call Rule 33 of the Texas Rules of Appellate Procedure, which requires a contemporaneous objection. And if you don't get that objection, well, it's gone. So you may have tried a great case and worked on your defense and worked on those instructions. Instructions is an exception, but as far as preservation. But then if you're not thinking about that appeal, you haven't helped the appellate attorney. You hurt the appellate attorney. So the litigators have to start thinking not only in terms of what do I need to do to get an acquittal, to get a reduced sentence, whatever, but what do I need to do in order to protect this man, this woman I'm representing on appeal? You just waving or what? Okay. So there's got to be a focus on that interrelationship. It's mandatory. It's mandatory that there's a focus on the interrelationship between the trial and the appeal. Trying to figure out why we don't have a lot of attorneys wanting to be appointed in criminal appeals. And apparently they all think many's mean because they said, well, the court's mean, or we're afraid, or we just really don't know how. Well, all you do is write and you argue. Who doesn't know how to write and argue? Yeah, there's some little nuances here and there. But I think one of the guidelines has to stress, be willing to have an open mind. And be willing not to be afraid. Yeah, the appellate court's a little different because you have 3 judges, or if you get en banc, it can be up to 15 judges in some courts. I think Dallas court, or 9 judges in each of the high courts here, and it's pretty intimidating. You have these people in black sitting up above you, and it's pretty intimidating. But some of the most fun I had when I was practicing law was getting in a judge's face. Now, maybe that's just my warped personality, but it's fun. It's the give and take. And to me, that's the closest you'll ever get to law school, if you like law school. It's the give and take of the law. It's the ability to argue in Gideon versus Wainwright why that person should have an attorney. Or in Akey, why it is unfair that the state has all this money and those who are defending themselves against the state don't. It's the give and take. You can't be afraid to do stuff like that. I was listening to our next bar president, Buck Files. He's talking about some of the problems that appointed counsel has. They face no time to plan. Well, that's true in trial, especially if you're in the middle of litigation. Well, it's not true on an appeal. You get time to write your brief. You get time to think. No time to do good research. Well, you do on an appeal. because that's what you're supposed to do, is pull out those books and start working. There are benefits there. I don't know why people are scared of that. And I guess one other thing that I'd ask, I don't know if it's in the guidelines, it probably is, and I probably missed it. But I think one thing, if those are going to be used as a teaching tool for young lawyers and for other lawyers just to see what they need to do, it's a boon to be able to go over and talk to another judge. Say, Judge, I'm stuck. What do you think of this? And you get that input. Well, as a litigator, you can't come talk to a judge normally about a case. But you sure can talk to another lawyer. I think that is one of the avenues, one of the best resources out there is another lawyer. Go talk to Jack, I can't get your name out, I'm sorry. Stoffregan, he's seen it all. But every community has a Jack Stoffregan type out there that's seen it. And go talk to him. Don't be afraid. Yeah, we have egos. But the biggest ego booster is winning. So if I can talk to somebody else in order to win and get my ego boosted, why not? And I'm finding that a lot of lawyers won't do that, especially young lawyers. They won't do that. They feel that they're on their own. And to a certain extent, in appointed cases, and we've had to sit down on some attorneys appointed on appeals about what they're doing and the timeliness, but we always tell them, come talk to us if you're having problems. We can't talk to you about the case, but we can maybe steer you on who to talk with and what can be done. I'd like to see maybe those things added to there as well. We've got a lot of experience up here, but there's people like this throughout the communities, and I think that's got to be stressed as well. That's kind of my spiel.
Yeah, Scott?
Question for you, Jeff and Andrea. Do you think it's possible for a defense lawyer to meet the state bar guidelines if they are in a offer for a day situation where the judge says, okay, if you agree to plead guilty today, I'll give you, 6 years for your crack cocaine possession. But, but that's the offer for the day. Otherwise, you're just going to have to take your chance down the road. Lawyer has just met the client, and basically they have, defense attorneys put in a situation where they have to make a decision in a matter of, 4 or 6 hours. Is that enough time to meet the guidelines? And if you don't think it is, then what is the defense lawyer supposed to do?
Well, that's a good question. This is a great example of one of the reasons we wrote these things. Because what I want to see these guidelines used as is as a backbone stiffener for lawyers. No lawyer should tolerate that. We've got to take this offer today. On a drug case, for example, we've seen plenty of this in my jurisdiction. The offer is good for a day, and we don't want to waste time or money getting the drugs tested. So you're going to need to plead guilty without any kind of a lab result telling you that this even is the drug that the guy's accused of having, or your offer is going to get worse. Standard practice, money saver, streamlining and making it run more smoothly. Well, our hope again is that the guidelines can be used by lawyers who do want to do better as a way of saying, I can't do that, and I'm not going to do that because it would be unethical for me to do that. This is really the first time that we have begun to develop some kind of workable framework for criminal defense lawyers to use in trial. I want to see lawyers go to all kinds of trial courts and say, I need $10,000 for an expert on this aggravated sex abuse case because I have a right to that under ACCI. And in fact, these guidelines tell me this is what I need to be doing because I do want to be on a level playing field, that level playing field that Buck talked about. You've got to make that happen. And for us, this is a way for lawyers to make that happen. Anyway. Yes, sir, Abner.
But let's say if that offer is made with the condition, do you have an obligation to pass it on to your client if they're wrong?
Well, I think we'd all agree you've got to pass that offer on. Of course, the way that you pass it on is up to you. Yep.
And then if your client says, I want it, I don't want you to do any discovery, I don't want to negotiate, I don't want you to do another thing, but get me out of here right now. Then what?
Well, I mean, look, I think and I'm kind of surprised at the number of lawyers, and I'm assuming, is there anybody here that's a prosecutor, incidentally? Not that, like, you'd admit it, right? But no, seriously. And I'm not trying to veer off your question, but I do want to point out something that Justice Quinn raised earlier. He goes, where are they in this discussion about indigent defense? They're the ones that are driving most of this all of it, really, because they're the ones that are deciding who to prosecute, how many, and for what. Yet they are used to, and I think have grown very accustomed to getting all the resources they need to do that. We're the ones that are scrambling around trying to figure out how to deal with the actions they're taking with unlimited money behind them.
Follow that, if I may add real fast, Jeff. Jeff and I were talking about that at lunch. And I do think we are missing a big player here, and that is the prosecutor, for the exact reasons Jeff said, because they determine what to prosecute, but also because their mandate is not just to prosecute. Their mandate is to do justice. And isn't that what everybody here is trying to do, is to do justice? Justice includes good counsel. So, of course, there are different motivations, political motivations, other things involved too, community concepts that prosecutors listen to. But I think their involvement is very important in this. And if I may add, kind of quasi-answer your question, what you said, your client says, I want it now. Mr. Files earlier said, being an attorney is just one part of what we do. We're also a counselor. Is that when you come up and say, well, yeah, it sounds good now, but let's think about what's going to happen. Jeff was talking about the ramifications of pleading to misdemeanors. You can't get, the funniest thing, you can't get a license to kill bugs, but you can't get a manicurist license. You can't get a lot of other things. Did you know that? And that may be where your counseling part comes in.
I agree with you, and I find that practice in both prosecuting, but in this, I think this comes up for not just me, but other defense attorneys, particularly that do this kind of work, where you have that conversation. These are your options. This is what I would normally do. This is what I think you're entitled to. What do you think about giving me a moment? And then they say, well, that office could be on the table tomorrow. And you say, it doesn't happen. If they say it's not, it's not. Now, I mean, I agree with you, but there's a dilemma there. There's a point at which the client is as much information as you can in that moment read with you wants to take the lead. Even saying, look, I don't know what it is. Even if you go through a brief accounting of how they've been being accused of it, and they're saying, no, I don't want to come back here. I don't want to do this anymore. This sounds good to me. Take it. Now, is there a point at which I've got an obligation to tell them I can't in good faith do that? You're on your own.
Listen, Abner, I got to tell you too. We got the signal, the hook signal. Like, we have 30 seconds left. Or it's over. Here's what I want to say. That is a great example of the kind of dilemmas that are going to be, in my view, and I'm doing this so as to not disappoint Tony Fabello, because, yes, I am really grim about the future. These dilemmas are going to get worse in the future because, frankly, I believe at least that the money is, at a minimum, not going to expand in this area and is likely to continue running out. As that happens, these pressures to move cases quickly are going to increase. pressures on the lawyers doing them are going to increase. And as far as the misdemeanors go, incidentally, as we were talking about before, I don't know if most of you all realize that's been turned into just a cash cow. I think 70, 80%, according to the commission numbers, of misdemeanor cases are being done pro se. Now, something's wrong in a county like that. Somebody's working on getting those people to plead without a lawyer. Anyway, these are the kind of fun issues that the future is going to present for us. Our hope is the guidelines are going to help criminal defense lawyers do better and hold the line against what's coming in the future. And thank you all very much. Justice Quinn, thank you. Andrea, and I appreciate it. Thank you.